has not happened, and that is the reason why we are here today, to seek the validation and approval of the court for the withdrawal. We have embodied in line with Rule 41(1)(a) the consent to pay costs, as the court has may have noticed in one, and we simply and with humbly request the court to endorse our withdrawal.
Let me try and understand the concept of withdrawal. What does it actually mean?
We're simply withdrawing the whole action. We are the plaintiff,
Yes.
and we are in a way withdrawing our claim against any party that may be affected by our claim
Yes.
in the action.
But does that mean that there might be a change of heart later? That's what I'm trying to find out. Is it a complete stop, abandoning, and renouncing whatever it is that the plaintiff has done, or is it only for now? Maybe something is happening. I need to understand.
Not necessarily a temporary withdrawal. The plaintiff has considered its own position and decided there is no more proceeding with this proceedings, and I am sure the court will make a determination in terms of whether this matter may be resurrected at any stage. But the instructions I got is that the plaintiff is withdrawing the whole action in total, and he has turned out to pay the costs for it.
Okay.
Thank you.
Very pleased, my lady. On behalf of the second defendant in the action and the applicants in the application before your ladyship, we have also served our notice of withdrawal, and it was contacted by the fact that it was already handled, there was no consent, and we then withdrew that notice and sought consent in terms of a fresh one, and failing which we would seek leave from this court to withdraw. And my lady, we haven't received any response regarding the consent, and what is before the ladyship at the moment is the issue of the granting of leave. In terms of Rule 41(1)(a), and my lady, one is very much aware that the court can grant such under exceptional circumstances, and my lady, that there is no onus placed on the applicants to state that, and the rule further states that the court is not inclined to seek or find out the reasons why the litigant no longer wants or wishes to proceed with the action or with the proceedings. And to that extent, my lady, we submitted that in the absence of consent sought from the other parties. Well, there are some other parties who have stated that they do not have any objection to the withdrawal. And the second defendant attempted to do that timelessly in order to avoid the cost implication. And my lady, second defendant has complied with the rules, and we are now in your ladyship's hands in terms of the granting or otherwise of the leave sought, and those are our instructions. I have draft order first and third defendants, and my lady, I don't think perhaps it's an appropriate moment. We will respond to that after they have addressed to the issue. As you wish. And my lady, my apologies. My lady, with us is different. With the second defendant, it's different. We will no longer be pursuing. It's not the temporary withdrawal. It's a complete withdrawal.
Thank you. Lady, our position is as follows. The application under 1193/516 was launched on the 8th of March 2016, some 7 years ago. And the action under 14038 was launched in February 2019. So this case has been running for a number of years with amendments, joinders, discovery, witness statements, served before many judges, served before Milady for some 3 weeks in February, and the matter was postponed until today. And out of the blue, without the courtesy of a letter, without a telephone call, we received on behalf of the parties, the plaintiff on the 4th of July served a notice of withdrawal, and the day before, the second defendant applicant in 11935 served also a notice of withdrawal. We then raised, by way of a Rule 30 notice, the fact that there was non-compliance with Rule 41. And Rule 41 provides that when a matter has been set down, it can only proceed with, it can only be withdrawn with the consent of the parties or with the leave of this court. Having served the notice in terms of Rule 30 to set it aside as an irregular step, Leonard, what he said, did not respond to that. He did not seek our consent. Chapiso Modise, failing which he says that he will apply to the court for leave, as Mr. Mangalela has done. Now, we did not give our consent because we were not sure as to what their intention was. Well, was this matter going to be withdrawn today and a new summons issued tomorrow and a new application tomorrow, in which event we would not agree to it at all. But we've now heard that this is not a temporary withdrawal, this is a final withdrawal. So the matter will not proceed. We will not expect then a new action or a new application. And on that basis, once we now know that, the only outstanding issue concerns the question of costs. Because the costs which have been tendered are party and party costs. And our position is that there should be, in fact, attorney and own client costs, but we are prepared to accept attorney and client costs. And that is the reason why Mr. Mangalela has referred to an order which we prepared, which we've shown to our colleagues, in which we propose that Milady grants such an order, and which we seek attorney and client costs. And it would seem at this stage that the only issue then is whether they should pay the costs they've tendered, or whether they should also pay attorney and client costs, which is obviously a punitive cost order, which we believe we are entitled to. So our position, Milady, is that if they are not prepared to agree to attorney and client costs, and in fact, since we've shared it with our colleagues, may I hand to Milady the order that we propose, which includes a cost order on the attorney and client scale, including the costs of free counsel, which has been the position up till now. Milady has given 2 judgments where Milady has granted costs of free counsel. At one stage, I think it was the plaintiff was represented by 4 counsel. So there shouldn't be an issue about that. The only issue, Milady, is attorney and client costs. So if that is opposed, then I would ask Milady for leave to argue the question of attorney and client costs. That is our position. We feel, and I'll come to it, that after what has happened, how long this matter has dragged on, and then suddenly we get a notice of withdrawal without any reason. Milady hasn't even given any reasons now, and we believe that attorney-client costs is appropriate. It's an argument which I'll address with reference to some authorities. Thank you.
lady, I am sure the court having been given the draft order by my the code of costs that is being raised there. In paragraph 2 of that, the first are raising the issue of the dismissal of the action. I don't think I've heard Mr. Epstein hinting much about that, but it's embodied in this draft order. It would be a contradiction in terms to accept that, to concede to the withdrawal and at the same time request the court to dismiss the matter. I have no problem with the issue of course being argued, but as the court and my colleagues are aware, discretion of the court, and the plaintiff has tendered cost on party and party scale. And then, other than that, my lady, I cannot take it any further. But I just wanted to hint that what is contained in paragraph 2.1, which specifically affects the interest of the plaintiff, cannot be accepted. We cannot talk of a dismissal of an action while there is a concession of a withdrawal. So if the withdrawal is conceded to, then the issue of a dismissal falls away, and we can now talk the issue of costs.
Have we discussed this draft before?
Well, the draft was circulated among us, and instantly, at the instance, in a moment, having read it, I rejected it because it would not serve the interest of the plaintiff, insofar as the attorney and client scale is concerned, and also in respect of the issue of whether the court should dismiss the action or whether the withdrawal should be maintained.
So if I understand you correctly, so even if it's a permanent withdrawal in terms of your instructions and in terms of your submission, even if it's a permanent withdrawal, that does not correlate to using the word to be dismissed.
No, one may not think of a dismissal without the reading of evidence to start with. So that paragraph, I would say, perhaps should not be taken into account if the court is amenable to considering this draft. We have no problem with the issue, of course, we have already tendered that, but what is at in dispute is whether the cost on attorney and client scale or the costs on party and party. And we concede that the issue of cost is a matter that falls within the discretion of the court.
Now, my lady, the fourth defendant has consented to the withdrawal. The fourth defendant.
Yes, fourth defendant has consented to the second defendant's withdrawal.
Yes.
It's on case line.